There were a lot of discussions before the UPC launched last June that many companies would opt out their patents and wait to see how the court performs before engaging with it. Now we're 6 months in. Can you talk us through how that's panned out so far?
Thanks, Emily. That's right. There was a lot of hesitation about how the system would be used and who would be taking advantage of it when it first opened. And I think there's probably three factors I would look at when thinking about the popularity and the take-up of the court. Firstly, the level of opt-outs, the level of take-up of the unitary patent, and then, of course, who's using the court and the number of cases. So firstly, in terms of number of patents opted out of the system by patentees, it's over around 550,000 opt-outs, which is quite substantial if you think about that in terms of the number. This includes both granted patents and applications, so it's a bit difficult to work out what proportion of the overall European patent portfolio in general that represents, because obviously there are applications that are no longer live due to the passage of time. But certainly I think it's a significant number of opt-outs and perhaps more than was expected. In terms of technologies, it's difficult to look at the proportion again. Looking at IPC classifications, early data showed no more than 11% of opted out patents in the field of medical devices, 10% for batteries, and roughly 8% for both wireless communications and transmission of digital information. So it didn't really show one clear industry being dominant in terms of opt-outs, and that generally it was across the board. But difficult to say because obviously you are looking at an imperfect data set. On the other hand, the take-up of unitary patents has actually been quite popular. And there's been a number of them filed since this became available on the 1st of June. And in fact, some people were delaying the grant of their European patent in order to get unitary protection when that became available. According to the EPO dashboard, there's currently nearly 14,500 unitary patents that have been registered since the 1st of June. And to put that in context, in 2022, around 80,000 patents were granted as EPs. So unitary patents have only been available 6 months of this year. And so that's roughly 35% of those patents requesting unitary protection. If you were to annualize that over the year, you'd be looking at more like 17%. And maybe that's a better figure, given that we knew that some people delayed the grant of their patents in order to get unitary protection. So, but even on a monthly basis, the take-up of the unitary patent is significant, and we know that there are a number of advantages to patentees in terms of translation costs, validation fees, and maintenance fees that would make unitary protection an attractive option for them. And then finally, in terms of popularity, an indication of confidence in the court, we're looking at the number of cases that have actually been filed in the court to date and who those have been by. And so there are around 100 cases so far. And I suppose that has surprised many that the take-up of people choosing to litigate in the UPC has been so strong, but also that there's some really well-known names in industry that are now involved in the court. So on the more tech side, we've got companies like Ericsson, Oppo, Panasonic, Nokia, Huawei, Amazon, and Tesla. On the life sciences side, we've seen Edwards Life Sciences, Sanofi, Abbott Laboratories, Amgen, Astellas, and Regeneron. So while we're waiting to see how the court performs, there are some really well-known names who are experienced in patent litigation, who are jumping right in and going to be part of some of the first cases shaping the court.
Thanks, Amanda. That's really interesting. There's sort of two questions that came into my mind off the back of that. The opt-out sort of percentages by industry sector that you talked about, so kind of 10 to sort of 13%, is quite low. Do you have any sense whether that aligns with kind of value in the portfolio? So are they opting out their sort of more valuable patents and maybe testing the system with something that's less valuable?
It's difficult to see that from the data. I think anecdotally, we knew that some people were analysing their portfolio and taking different decisions based on the value of the patents and their intentions. On the other hand, I think there was people who chose to do nothing with their portfolios and leave them in the system on the basis that they hadn't been subject to revocation actions in the past, and they didn't really feel the need to do anything. So I suppose it's a mixed approach, and I think it's also interesting that within, say, the field of medical applications, that is in fact quite, and life sciences, that covers quite a range of technologies. And although we think of life sciences, we think of the opting out of crown jewel patents from the pharma industry. Actually, that's probably a small proportion of patents that fall within that classification. And there are lots of other people who may be thinking that they have a benefit, certainly, of obtaining unitary protection, or from having the option to centrally enforce across Europe through the UPC.
And the second question that sort of came to mind was, so you talked about there being sort of 17% an adjusted percentage of UPCs sort of annualized. Do you think that organisations are protecting more broadly now within Europe? Obviously, the UPC covers more jurisdictions, but I think previously there was kind of some key jurisdictions where companies would designate. So, you know, Germany, France, Italy, UK obviously out. So now, you know, I think the cost of unitary patent is about 4 times the cost of an individual national patent. So does that percentage kind of align with the breadth of protection that organisations used to have, or do you think that they're protecting more broadly, and so there's going to be much more of a focus on Europe and enforcement in Europe?
Well, it follows with a unitary patent that your protection is wider without having to pay the individual fees for each of those countries. So it certainly makes economic sense for countries that were validating in a large number of countries, or wanting the ability to validate in a large number of countries, to certainly follow that path. Speaking with some clients who had a more narrow validation strategy, a certain number of countries have actually decided, or their thinking is that if they have to validate for other non-UPC states that are members of the EPC, such as the UK and Spain, that actually the economics don't necessarily always make sense to validate as a UP, given that they've got to do those validations, and actually they would continue with a more narrow validation strategy. So I think people are making individual decisions. The other thing that's actually come out of the data that's quite interesting is who are filing for unitary patents and the country of origin of those applicants. And actually, predominantly, they have been European-based and EPC states, and with roughly 15% so far coming from the US, and that number is growing. And it's felt that perhaps Europeans, people who are familiar with the EPC in EPC states, are more familiar with the court and are more aware of what the advantages may be than perhaps patentees who are coming from different jurisdictions, and that over time perhaps that will spread out a bit more as people grow in awareness of the court and the unitary patent system, and also grow confidence in the system.
That's really interesting, because one of the comments that was made before the court launched in some of the podcasts that we'd recorded was that there was an expected kind of high uptake from Southeast Asian companies to litigate, but obviously we haven't seen that. I know that speaking to some Chinese practitioners, they knew that local organisations were going to be a bit nervous about a new court, and I think that aligns with what you've said, but interesting. So next question, we've seen the UPC pass the 100 case mark, with some divisions being more popular than others. What considerations should claimants take into account when selecting which local or central division to bring their claim?
Well, it's right that patentees generally have more flexibility and choice in where they bring an infringement claim compared to national proceedings, because you obviously have a number of local divisions located in different territories. But you still do need to satisfy the jurisdictional rules around either having a defendant domiciled in that local division, or the place of infringement occurring within that local division. So in circumstances where a product isn't available in all parts of Europe, or you have imperfect information about the nature of the infringement and who is responsible for it and where it is taking place, you might have already narrowed your choice of courts to where you have the best information in order to substantiate your claim. So I think while we did talk about a lot of forum shopping before, and that being a possibility before the court opened, as a practical matter, that's you do need to look at what information you do have in order to bring your claim, and that will be easier where a product is available perhaps online, or it's an app that's available for download, and therefore you may not have those issues. But certainly that's something that we are considering with clients when we look at where it is feasible to bring a case. Language can be another factor in where litigants choose to litigate, and we did think that that could be a factor that patentees could use to their advantage in selecting a language of the proceedings that's convenient to them, but not the defendant. However, we have seen now some decisions of the court that change the language into English and the direction, regardless of what it was initially filed in. And the Court of Appeal is understood to be hearing cases in English going forwards. So from a practical standpoint, all of the judges are competent to hear cases in English. And in fact, some judges at conferences and other meetings are encouraging the use of English in proceedings as that's the best way to share cases amongst the judges, which will help, the judges grow in the early cases, and also managing the caseload of the court more broadly across the pool of judges that they have. I think there's now a risk that a case filed in a language other than English may end up needing translations, either because the language of the proceedings has changed, or even for one of the judicial panel who doesn't speak that language or isn't competent to hear cases in there. And it's really not an ideal situation for litigants to have judges working off two different sets of documents. And so you can see that this is a situation that parties would want to avoid. So I think while we thought language could be a factor in forum selection, I think that generally is now falling away with some of the early practice of the courts. I think the other dominant factor that's been driving party selection of the court has been a preference for local divisions with two local members of the judicial panel. And so that's in territories where there is perhaps a more experienced judicial panel and greater experience of patent cases, so particularly Germany and Paris. And litigants think then that have greater certainty over who's going to be hearing the cases. So you've got certainty over two judges, and with a third coming from a pool of judges of a different nationality. It'll be interesting to see how this develops as users become more accustomed to less well-known members of the judiciary that gain experience in the court. Another key trend has been the filing of cases in Germany, particularly in Munich. Initially, the German courts did not accept proceedings in English, and that was a late change, and it was thought that perhaps some of these cases were already lined up to be filed in Germany before the court opened. And we've also seen a reduction in the number of national cases filed in Germany since the UPC has opened, by some estimate a factor of 50%. And so it could be that actually some of these are cases that would have litigated in Germany, and now they are being litigated in the UPC on that basis. The downside, I think, of this concentration of the court of the cases in those courts is that the German courts have some of the highest caseloads, particularly in Munich, and we'll have to see if that has an impact on the speed and time to trial compared to those other local divisions that perhaps have fewer cases on their docket.
I think the language point is quite an interesting one. If proceedings are going to be heard in English, then is there going to be a benefit for looking back for patentees to be filing their patents in English? So obviously there's always a translation into English, but if the original claim set was in a different language, there's always a risk that when you do the translations, then there might be some slight changes in meaning. Do you think that this could mean that patent filings of unitary patents are more likely to be in English than other languages?
I think that's true. I don't know in what proportion of the languages they're already being filed in English, and obviously that makes sense for a party with a global portfolio to be ensuring that consistency in any event.
So although there's not yet been a UPC trial, there have been a number of applications heard by UPC courts, from procedural applications to preliminary injunctions. Can you comment as to how the UPC first instance courts are performing, and will this instill confidence in companies who are waiting to see before engaging with the court?
Clearly, one of the benefits to companies of litigating in the UPC is thought to be the speed of proceedings and getting to a decision in comparison to what can be achieved in national proceedings in Europe, which, as we know, can be variable in terms of speed. So it's been really positive to see the first cases in the UPC getting off the ground and the speed at which decisions can be made. We did have an ex parte preliminary injunction made on the same day it was applied for in the Maestroma case. So ex parte being one that was made without hearing the parties. And so that allowed that litigant to get an order that could be enforced at a German trade fair that day. So it's reassuring that the court can act quickly if it's needed. And in the 10x Genomics case, which was the first inter partes preliminary injunction that was granted, they also obtained a quick result in the sense that the hearing was within 3 months of the filing of the case, which was just when the court first opened, with a decision given 2 weeks after the hearing. So many companies are going to look at that favourably if they do need preliminary relief before trial. Secondly, companies are also looking for the quality of the court and how that might instill confidence in their use of the court going forwards. And I think what we have seen is encouraging. And the 10x Genomics preliminary injunction hearing was heard over a day and a half of submissions at the court, and the court delivered over 100 pages of written reasoning. So without going into the underlying merits of the decision, the oral arguments exceeded what many European practitioners would have been accustomed to in their national proceedings for the level of scrutiny that's given before a preliminary injunction is granted. And that's only fair that it is a rigorous process, given that it would be potentially an injunction that covers such a wide territory. So overall, I would say that it's the early decisions have been building confidence in the system, although we haven't yet seen how the court decides matters on the merits. I already mentioned a number of well-known names using the system. One caveat to that is that many of the UPC cases filed so far are an extension of existing European or global litigation where parties have really already kicked the tires on the patents and the validity arguments and issues in those cases, and some of those cases have already been decided by other tribunals. So this, I think, for those litigants, perhaps proposition to filing fresh cases on untested patents, where companies might see the proceedings as having a higher level of uncertainty or risk regarding the result. So there is some initial confidence in the system, and there are a number of cases that are going through and being decided that give confidence to people. But still, I think it's fair to say that some of the parties that have chosen to litigate in the system have done so with their eyes open and with the benefit of having litigated those patents before.
We've now seen the first ruling from the Court of Appeal clarifying the rules of procedure on filing a claim. Does the decision give much comfort that the Court of Appeal will fulfil its role in applying uniform case law across UPC proceedings?
It does give some comfort, but overall, I think there have been fewer appeals that have gone to the Court of Appeal than had been expected. The Court of Appeal is a very powerful way to drive forward practice of the court and jurisprudence and give guidance to practitioners and to the first instance courts. But the Court of Appeal can only consider matters brought by the parties before it, and it doesn't act in advisory capacity. So there's a further cost associated with appeals, which may put parties off taking procedural matters forward. And the other thought is that parties are working to very condensed timetables, and advisors may be opting to focus on their time and attention on the substantive case rather than to pursue an appeal on a procedural matter when there are a lot of other things to do to get your case ready in the background. So I think that's perhaps why we haven't seen as many appeals on procedural decisions as we might have expected, this being a new court and something where the legal arguments and jurisprudence is just forming. There is an ongoing appeal in respect to access of documents in the UPC system, and we had 2 central division decisions from Munich that applied quite a restrictive approach on access by third parties to pleadings in the court system, and a Nordic-Baltic regional division which was more generous on access to third parties. And my understanding is that matter is now going to be considered by the Court of Appeal. And it's very reassuring to see that, because it has far-reaching implications on users of the court, and is a practice that needs to be consistently applied across all of the UPC courts. But the court is only able to consider this because that matter has been appealed. Otherwise, it doesn't have standing to just issue rulings, even if there have been inconsistent decisions. It only can consider what parties bring to it. And another side note is that we've also seen some divergence across different registries on how some formalities are being complied with, and how cases progress with the CMS system and the various steps and stages that have to be complied with. And the court has been acting on feedback and implementing improvements to the system. But I think over time, I think practitioners and companies would like to see some more guidance issues on some of the practical points of engaging with the CMS system, and so that these can be consistently adopted regardless of which division you're working in.
I think that's right. And I think we've seen some kind of more guidelines come down in terms of, and possibilities come down to sort of smoothen that. So in terms of having a team that can now be named as a representative rather than a single representative. So more to come.